It's a great pleasure to see you here. My name is Manuel Eisner, and I'm the director of the Institute. And it's my great pleasure to welcome you today, this afternoon, at the Nigel Walker Lecture. The Nigel Walker Lecture is the most important annual public lecture that the Institute of Criminology organizes. The Nigel Walker Lecture was inaugurated in 1997, and it's named in honor of the Institute's second director, Nigel Walker, who served as Wolfson Professor of Criminology from 1973 to 1984. It's an annual lecture given by a prominent eminent criminologist, and over the years, Nigel Walker Lectures have been given, amongst others. I just name a few people who have presented this lecture: David Garland, Stanley Cohen, Rob Sampson, Andrew Ashworth, Peter Reuter, Adrian Lane, Richard Tremblay, Susanne Karstedt, Claudia Garcia Moreno, Candice Crutchmit, and John Braithwaite. Just to name some of the external contributors to this lecture. But before I introduce the speaker today, I would like to also announce the winner of this year's Nigel Walker Prize. The Nigel Walker Prize is awarded annually for an outstanding written contribution in a PhD in the field of criminology by a member of the University of Cambridge, and it was first awarded in 2007. Now, I also want to mention that many former prize winners of this prize have become outstanding criminologists both here and internationally. So at the Institute, for instance, Justice Tankebe, Karl Treiber, and Maria Toffi, Jane Dominy all won the Nigel Walker Prize for the best PhD. But I would also like to highlight that many have become very well-known international criminologists: Joe Murray at the University of Pelotas, Leo Kiliotis at LSE, Sarah Bennett at the University of Queensland, Amy Nibet at the University of Utrecht, Thomas Akoenzi at Kent University, Brianna Fox in South Florida, and Esther van Ginneken at the University of Leiden. And just recently, I just wanted to also celebrate some of the recent winners of the PhD prize. Nina Triveda-Bateman, who is now lecturer at the University of Loughborough, Thomas Akoenzi, who has become a lecturer at the University of Kent, and these are just two of the recent prize winners. Today, I'm pleased to announce Eleanor Brown as the winner of this year's prize for the dissertation on prison segregation, the limits of law. Now, when I say this, I have to admit that this announcement has caused me some pain, because sometime this afternoon at around 2, I realized that we had not advised the prize winner, which was a bit of a shock, I have to admit. So we immediately did advise the prize winner that this had actually happened. And she is, I'm glad to say, she is actually happy that she has been awarded the prize. But she is not able to be here tonight, probably not surprisingly. And she allowed me to announce that she's won the prize today. She was supervised by Alison Liebling, and I just wanted to say that one of the reviewers wrote, which I think this is a lesson for all the senior academics here in the room. One of the examiners wrote that this is well above the threshold for the award of a doctorate, and in almost all respects higher quality than the majority of research published by people with senior academic roles. I thought that's a very good thing to write into a PhD assessment. But today we have the great pleasure to introduce, I have the great pleasure of introducing the speaker for this year's Nigel Walker Lecture, Professor Loraine Gelsthorpe. Loraine is a professor of criminology and criminal justice emerita at the Institute of Criminology. She's also a fellow at Pembroke College, and she was the director of the Institute from 2017 to 2022. And prior to that, she was the deputy director for a number of years and served for a number of years also as PhD director and MPhil director. She had wide interest in the links between criminal justice and social justice, examining race, gender, and social exclusion, women and sentencing, and women crime criminal justice topics more generally. Her research includes a focus on the effectiveness of youth and community penalties and pre-sentence reports. She also has a strong interest in research methodologies and research ethics, human trafficking and the criminalization of migrants. She has published 12 books and over 200 articles in criminological journals, and she was the recipient of the European Society of Criminologists Lifetime Award in 2021, and she is this year's winner of the British Society of Criminologists Outstanding Contributions to Criminology Award. I just want to highlight two topics. She's conducted important work on the complex link between criminology and feminism, and she started with this work in the late 1980s, before many others were writing on this topic, and she's really, she's recognized for having had a lasting influence on this field. Loraine has lived in Cambridge since the early 1980s, when she came to do an MPhil in criminology here. And then the call to do a PhD was stronger than the return to working as a social work in a social work career. And after the PhD, she had a number of postdoc appointments at Lancaster, Bangor, and at LSE, which involved work with, for instance, the police and on topics like diversion from prosecution. She began working at the University of Cambridge in 1991, and she was president of the British Society of Criminology in 2011 to 2015. She's a fellow of the Academy of Social Sciences and a fellow of the Royal Society of Arts. And everybody can read this, who wants to read this on her CV. And she talks about this. She was a year 11 plus failure, and increasingly sees this as something that she also wants to share publicly, having difficult school careers is not something that determines these things happen, and she's become a very, very successful academic. And she encourages others whose own routes into higher education may not be traditional to also talk about this and be open about this. She is a psychoanalytical therapist in her spare time and a trustee of Pendrick House, a community centre in Walworth, South London. Loraine, it's a great pleasure to have you here, and we all look forward to your talk. Thank you.
Thank you very much. Thank you very much indeed for that generous introduction. I do indeed mention the 11 plus, which for those who don't know, was an examination that people took aged 10, 11, and school children were divided into the clever ones who would go to prep grammar school, and then the rest of us who were sent to secondary modern schools, which subsequently became comprehensive schools. It's a great honour to give this lecture. Nigel Walker was director when I came to the Institute, and he taught me in the MPhil class on penal theories, a grounding which has remained with me ever since. When I visited Nigel on one occasion when he'd retired and was living in Edinburgh, he was surrounded by books. And I asked him what he was reading, and he said, only philosophy. I've given up on criminology and all that nonsense. That rather made me gulp, but it did remind me that it was studying moral philosophy alongside social history in the 19th and 20th centuries as an undergraduate, which fueled my interest in criminology. And it fueled my interest in the links between criminal justice and social justice throughout my career. And one message I want to give, as director of the Institute whilst I was a PhD student, Nigel instituted the idea of wine after the Thursday seminars. And that was initially only for PhD students, and then it was for MPhil students. And it was most certainly a bribe to attend the seminars. And there is wine for afterwards as your reward for coming. Nigel examined my PhD alongside Dame Janet Finch, who at the time was Pro-Vice-Chancellor, no, she was Vice-Chancellor actually at Keele University. And in discussion with them, I learned something about the difference between paper justice and real justice, which has stayed with me. So my topic, women, crime and sentencing. My lecture is in 5 unequal parts, I hasten to add. But the key question to keep in mind is what should equality for women in sentencing actually look like? So here are the 5 stages of my journey in this lecture, with a journey to Nigel Walker's beloved Scotland towards the end of my talk. So I first of all want to refer generally to past research on women and sentencing. Looking at any previous research findings on sentencing quickly lead to the conclusion that there have been differences in the way in which men and women have been treated in the courts over the years. The disparities in treatment are all too evident. But whether or not such differences can be justified is an interesting question. And this is the question that I want to pursue in this lecture. On the one hand, women commit fewer and less serious offences than men. National figures in relation to crime suggest that 4 in every 5 offenders are male. Briefly, men outnumber women in all major crime categories. Indeed, between 85% and 95% of offenders found guilty of burglary, robbery, drugs offences, criminal damage or violence against the person are male. Where women do offend, they're more likely to commit property-related offences than anything else. There have been, in recent years, slight increases in lower-level violence around pubs and clubs, and also increases in drugs-related offences as for males. But neither of these things suggest seismic changes in patterns of crime. Indeed, if one digs deep into the statistics, one can see that it is young women getting drunk and committing minor assaults around pubs and clubs. And when it comes to drugs offences, women are more likely to be prosecuted for possession of drugs than the sale of drugs. Broadly, women commit less serious crimes and they're less likely to persist in crime than men. It follows that we might expect sentencing patterns to reflect these differences. But analysis suggests that some women are as likely to be treated severely, if not more harshly, than men. Looking to the past, close analysis of the treatment of women in the courts has revealed that sentences take into account a whole range of factors relating to gender differences, and some of these are relevant to the task, some are not. Indeed, notwithstanding sociological analyses, which suggest that the whole sentencing arena has changed to reflect a punitive term in late modern society, it's arguable that a penal welfare complex, which emphasises the dominance of familial ideology, has prevailed in relation to the treatment of women in ways harsh or treatment lenient, depending on how far women conform to the gender role stereotype. In the mid-1990s, Carol Hederman and I were commissioned by the Home Office to resolve the question of whether women were being treated more harshly or more leniently than men once and for all. Needless to say, all we discovered was that it depends. At the same time, there have been strong arguments to suggest that women ought to be treated differently from men, not just in terms of the lesser seriousness of their crimes, and the risks that they pose to the community in terms of reoffending, but in terms of their criminogenic needs. So I want to review gender and sentencing issues in England and Wales, but more particularly focus on the arguments and supporting evidence that women ought to be treated differently from men on grounds that they have different needs. Such arguments gained credibility in the light of the gender duty enshrined in the Equality Act of 2006 and subsequently in the Equality Act of 2010, which brought together different pieces of equality legislation. This development highlighted the need to give proper consideration to gender differences rather than relying on myths, muddles, and misconceptions which have configured in sentencing in the past. But how best to do this? Let me elaborate a little more on the fluctuations in sentencing. Certainly, there have been historical fluctuations in the number of women in the courts, but for the most part, men have dominated, and the appearance of women has been a rarity. Lucy Zedner vividly describes controversies concerning the sentencing of women in the Victorian age. There was particular interest following the publication of Women in Prison by Anne Smith. Nigel gave me his copy, in which she paints a clear picture rather of the sorry lives of women within prison. In Holloway Prison, no longer exists, of course, it was decommissioned in 2016. And an article by Frances Heidenstone in 1968, where she questioned the invisibility of women in the study of crime and deviance and its implications for sentencing. The 1970s brought the publication of Carol Smart's book, Women, Crime and Criminal Justice, in which she not only questioned why so many women were being imprisoned for relatively minor crimes, but offered critical reflection on the possibility that there might be a functional equivalent between prisons for men and psychiatric hospitals for women. However, women's predominance in psychiatric hospitals at the time could be explained by a number of different factors, ranging from women's longevity to psychiatric sexism. But the question set in train some critical thinking about the treatment of women in the courts and a series of empirical studies, many of which focused on the possibility that women were being treated either leniently or harshly compared to men. Notwithstanding some methodological idiosyncrasies and limitations, the various analyses resulted in somewhat conflicting and contradictory conclusions. With a ban, she was free, but courts at the same time condemning women. Contemporary criminal statistics, sentencing statistics in England and Wales seem at first glance to support a chivalry hypothesis. Since a far greater proportion of women than men are cautioned, formally warned by the police rather than being prosecuted as such, although cautions can be cited in court if a person subsequently reoffends. Cautions are meant to apply only to minor offences, and there are strict conditions on when they might be used, and the offender has to admit the offence to receive a caution. This phenomenon applies across different age groups. Moreover, discharges and the fine are popular dispositions for adult offenders, but a smaller proportion of women than men receive custodial penalties, and a greater proportion of women than men receive probation or discharges in the courtroom. Compared with men, women are also generally given shorter sentences of imprisonment for all offences except drugs. However, these statistics don't necessarily show that women are dealt with more leniently than men. They show that women are dealt with differently from men, but they don't show us why this occurs. A number of researchers have thus attempted to unravel the complexities and mysteries of sentencing. David Farrington and Alison Morris, for example, of this institute, analysing court records and decisions in a magistrate's court, you can guess which one, found that there were similarities and differences in the relationship between different factors and the sentencing of men and women. For example, sentence severity was predicted by factors such as offence and plea for men, while it was predicted by factors such as marital status and the existence of co-defendants for women. Moreover, women only received more lenient sentences because they committed less serious offences and were less likely to have been previously convicted. Using a different methodology involving a matching technique and looking at two magistrates' courts, Mayer and Brockington suggested that when matched, women were more likely to be discharged and less likely to be fined than men. Disparities in sentencing and sentences of imprisonment, however, were reduced by matching. Further research by Moxon in the Crown Court and Wilczynski and Morris in regard to case records of men and women who'd killed their children signalled leniency towards women. Although Dominelli's research on community service orders, now unpaid work in the community, research on community service orders pointed towards the possibility that women were given such an order, a relatively severe penalty on the sentencing tariff at the time, rather sooner than their male counterparts. Peterman and Huff reported that females were less likely than males to receive custodial sentences for virtually all indictable offences, except drugs, where it was equal. And they also showed that custodial sentences were shorter for females than for several offence types, except for criminal damage and drugs offences, which were longer. Previous convictions didn't explain the leniency towards women. And as I've said, in a study in the mid-1990s, which Carol Hedeman and I were commissioned to conduct, all we could say is, well, yes, some women are treated harshly, some are treated more leniently than men. Magistrates take different things into account. They see the defendants, male and female defendants, in front of them very, very differently. The magistrates mentioned using their common sense or gut feelings and commented on women's appearance and demeanour in court, much more so than they commented on the appearance and demeanour of men. In subsequent research, Flood-Page and McKee found that in magistrates' courts, a greater proportion of female first-time offenders received a community sentence and a discharge, and a smaller proportion were given a fine compared to their male counterparts. In the Crown Court, a greater proportion of male first-time offenders received a custodial sentence, a community sentence, or a fine compared to their female counterparts, who were more likely to receive a suspended sentence or a discharge. I could go on talking about these complex characteristics of sentencing in the court. I could go on to talk about different report writing practices, pre-sentence reports, what used to be called social inquiry reports, where the focus on men and women in those reports was very different. I could also go on to talk about magistrates' perceptions of those before them. They perceived women's offending very often to be rooted in poverty and financial dependence, for example, and considered, therefore, that financial penalties were often inappropriate sanctions for women who offended. However, some of the women got a lesser penalty, and some of the women got a more severe penalty for the same reason, that it was thought that their offending was rooted in poverty. Further, various studies in different parts of the UK have found women to be underrepresented in community service, now called unpaid work, as I've said. There were clear differences in the characteristics of men and women sentenced to community service. Women were more likely than men to be first offenders, for example. Indeed, a thematic review of provision for women in 1996 showed that probation officers preparing pre-sentence reports often rejected community service orders as a viable option for women with childcare responsibilities, and indeed were unaware of the funds available for childcare provision. That was a long time ago, of course, there's no such provision now. Moreover, there was a perception that women posed a higher risk of breach on such orders due to family responsibilities, despite evidence to suggest that women have had more successful completions when doing community service. Sue Rex and I did a major study of community service showing that women actually were very successful. Combined with observational research in the courtroom, accumulated research evidence has suggested that sentences treat women differently from men due to chivalry, paternalism, family protection, or enforcement of gender-appropriate behaviour. But what's also clear is that sentences have operated a bifurcated system of sentencing, which distinguishes between those women who conform to gender stereotypes and those who do not. At the same time, what's unmistakable is the fact that sentencing of women, as with the sentencing of men, has taken an increasingly punitive turn over the last few years. David Garland offers a detailed and insightful historical cultural account of how the crime control developments witnessed in the late 20th century have adapted and responded to the late modern world, with all its social transformations relating to globalization, technological developments, the loss of traditional communities, and so on, and to its political and cultural values. Garland's analysis revolves around the notion that we can understand the development of strategies of control by thinking about punishment control as a cultural adaptation to late modernity and the free market. In other words, he tells us that we need to understand the socially conservative politics that came to dominate the USA and the UK in the 1980s in order to understand the culture of control, what critics have previously described as prison centricity, and what might be described as the carceral centrifuge. There are many positive features to the culture of control by David Garland. They include the independence, recognition of the interdependence of social, economic, and political influences, his recognition of the links between crime and punishment, and the emphasis he gives to the public in terms of their lived adaptations to the new crime control situations that face them, rather than seeing their views as mere reflections of elite spokespeople within politics or the mass media. The storyline is simple: a penal welfare complex, by which he means rehabilitative interventions and individualized sentencing based on careful assessment of needs, has given way to a culture of control, and we are currently witnessing ever increasing prison rates. The fact that we are witnessing that is a straightforward reflection of this. But the omission of any major consideration of women in this important commentary on the growing culture of control in England and Wales epitomizes one of the problems endemic in criminal justice policy itself: the continuing invisibility of women. Indeed, although Garland does not give recognition to this, The treatment of women in the book illustrates well the apparently dualistic and polarized penal policies that Garland describes so well in the book. We should note one or two particular things here. Firstly, that the feminist critique of criminology has identified that beliefs about female offenders, which locate their offending behaviour in the discourse of the pathological, have long since persisted, despite the introduction of more sociological and social constructionist ideas in relation to men's offending behaviour. The discourse of the pathological, of course, lends itself to penal welfarism. Secondly, looking back in history, we can see very clearly how penal welfarism developed for women. Calls for differentiation in the treatment of male and female offenders from the 1850s onwards has led to a number of, or did lead to a number of significant changes in the 19th century, ranging from the special provisions for the Women's Police Service to take statements from women and children, to plans for the redevelopment of the main women's prison system, HMP Holloway, in the late 1960s, so as to accommodate their special needs. The idea was to rebuild Holloway Prison as a therapeutic community. Institutional arrangements for women aside, the sentencing of women and the content of institutional regimes provided for women and girls within have long since reflected elements of the penal welfarism that Garland describes so well in The Culture of Control. First, a woman who enters the criminal justice system can be described as incongruous, and Worrell describes such a woman in that way. Explanations for her presence are sought within the discourse of the pathological and the irrational, menstruation, mental illness, poor socialization, and even the menopause have all featured in explanations here, and all of course, have been subject to critique. Men are not viewed as so out of place in the courtroom, and so their offending is explained in different ways within the discourse of normality and rationality. In addition, and as previously indicated, certain factors such as marital status, motherhood, social problems, and welfare needs seem to influence the sentencing of women, but not that of men. Pat Carlin, I think, captured the nature of the penal welfare direction of the treatment of women in British prisons, for example, in her memorable claim that women's prisons discipline, infantilize, feminize, medicalize, and domesticize those within. Since all of that research, I think it is now recognised that not only has women's offending been underexplored and less well understood than offending by men, but it has gradually been recognised that women are likely to have different criminogenic needs because their routes into offending and reasons for offending are often different from those of men. Some needs are similar, some are different. And as Carol Hederman has concluded from her own analysis of research on men's and women's criminogenic needs, overall, the available evidence suggests that programs which focus on male criminogenic factors are unlikely to be as effective in reducing reconviction among women offenders as they are for men. A focus on criminogenic needs has been driven by, and in turn has driven, the use of structured assessment tools in probation practice. Those tools are gendered. Those tools have led to a conversion of risk and need, with women being high in terms of assessment of their needs, but low on risks of committing serious offences. Critics of evidence-led policy and practice have also drawn attention to important differences in developmental processes between women and men. In other words, different approaches work for men and women in interventions. Educationalists, for example, have argued that women's learning differs from men's learning, both in terms of its developmental sequence and in terms of its underlying theory. Researchers argue that women view knowledge more as a set of connections than a set of distinctions, and that most women prefer to learn in collaborative rather than competitive settings, and so on. What does all this mean? Where does it lead us? There have been a number of bottom-up initiatives amongst probation practitioners developing group work programs. There have also been some top-down initiatives to recognise the differences. So I want to look, or I want to move towards the issue of dealing with diversity, difference, and justice. I think, returning to a point I made earlier, I think a key part of the Equality Act, and then subsequently the 2020 Equality Act, which brought into play the gender duty, has been very important, especially in promoting the introduction of gender impact statements. A move which highlights the need to give further attention to what works for women in sentencing. Of course, the equality of treatment need not be equated with the same treatment. In other words, whilst it's important that negative discrimination is avoided, it's equally important that dimensions of diversity are appropriately accommodated as a means of promoting both procedural justice and social justice. Tom Tyler identifies a number of factors that can impact on offenders' perceptions of procedural justice. So just let's pause and think. Okay, a lot of evidence which shows that men and women have been treated differently in sentencing and in the criminal justice system more generally, but not always for the right reasons. There's been stereotypical thinking, beliefs, differences in the allocation of resources. What about reasons now for treating women separately? You could look at these slides yourselves, but I'm just going to whiz through them. These are slides drawn from the Prison Reform Trust, which is one of the many campaigning groups who suggest that women should be treated differently. Women should not be sent to prison. Women should be given lesser penalties because their backgrounds are different. Their routes into crime are so very different from the routes of men. And we see here, looking at women in prison, the high proportion of self-harm incidents in women's prisons. The high proportion of women in prison who report problems with their mental health. We have a reminder that women commit less serious offences than men. We also have a reminder that women are more likely than men to report feeling suicidal, back to mental health issues. They report feeling depressed on entry to prison, and they have other mental health issues. High proportion also have problems with drugs and alcohol. All these points are used in the campaign to suggest that women should be treated differently, should be sentenced differently. There is certainly a good deal of evidence to suggest that many women caught up in the criminal justice system in general, and many women in prison, have been victims of much more serious offences than those that they're accused of or convicted of committing. 53% of women in prison, for example, compared to 27% experience emotional, physical, or sexual abuse as a child. And it's argued that there are strong links between women's offending behaviour and their experiences of domestic abuse, coercive control, and sexual abuse. Here we have the figures on self-harm and self-inflicted death. Takes me back to Anne Smith's portrayal of women in Holloway Prison in the early 1960s, where she describes that they are a sorry lot of women. There are also concerns about women in prison, mothers in prison, and the separation of mothers from their children. Much is made of the separation of women and their children. So much so that motherhood is often seen to be a key mitigation in sentencing. At least the argument is that it should be seen as mitigation in sentencing. Women on remand, figures are also high, when indeed some of those women get community sentences. And it's 25% of self-harm incidents by women in prison were committed by those held on remand in 2021. A high rate of recall too, not necessarily because of new offending, but because women are in breach of the conditions of the licence upon release from prison. So a very sorry lot indeed, it might be argued. But where does this take us in regard to justice? We can pick holes in some of those arguments, motherhood as mitigation or parenthood as mitigation. But if it's parenthood as mitigation, why not elderly care as mitigation, so on and so forth. So if there is a case for differentiation, what direction should we go in? I think it's too simplistic to say women should be treated this way and men should be treated this way, almost as if there should be different, separate sentencing systems. In 1986, Frances Heidenstone raised the question of whether there is a female or feminist conception of justice that would be more appropriate for women than the modernist system of justice. And in attempting to address this, she distinguished between two models, which she called Portia and Persephone. Portia, the woman in Shakespeare's The Merchant of Venice, who tricks moneylender Shylock out of his pound of flesh, represents what can be broadly called the due process model, and it emphasizes rights, fairness, formality, and equality, supposedly. Heidenstone considers this model to be unresponsive to the needs of women and to be a masculine approach to justice. Persephone, on the other hand, the goddess of harvest, exemplifies the cycle of fertility and represents what can be loosely termed the welfare and rehabilitation model, emphasizing reformation, cooperation, informality, and reparation. Frances Heidenstone has argued that it's this second model which is more appropriate for women since it represents feminine values. However, on the one hand, it can be argued that Heidenstone's thinking does little more than replicate the traditional welfare approaches that have been criticised for stereotyping women. But on the other, we might argue, well, this kind of model could be equally applicable to men and women. And this is certainly something that's been argued by Masters and Smith, for example, who said, yeah, we need Portia and Persephone. We need an ethic of justice and an ethic of care in our sentencing and criminal justice systems. Mention of the ethic of care, of course, brings us to Carol Gilligan's research into the gendered nature of moral reasoning. Gilligan argues that an important part of a feminist ethic is that it rejects solving moral problems through the categorical application of fixed rules and principles. Paper justice, we might say, without reference to the context, needs and capacities of those involved. Real justice, we might say. So what kind of system do we want? A recent bill, at least a bill was presented in Parliament, continues this idea of there being a different sentencing system for women. Daisy Cooper, Lib Dem MP, produced a bill, presented a bill to say that the courts should impose community sentences on women offenders unless they have committed a serious or violent offence and pose a threat to the public and for connected purposes. In other words, completely separate criminal justice system. I have not found anything published on this. I suspect that it didn't go very far. Well, what about problem-solving courts? Would that be a way of dealing with women's particular needs, women's specific needs in the court? Certainly, adult drug courts have produced a positive response, reducing substance abuse and reoffending. Juvenile drug courts, incidentally, have had minimal or indeed harmful effects. Family treatment courts, some have had positive effects. There have been 3 women's problem-solving courts in Aberdeen Sheriff's Court, Stockport Magistrates Court, and then Manchester and Salford Magistrates Court. These courts are still, even now, described as pilot studies. There's a new one going to be developed in the West Midlands, which is designed to combat female offending. It has just been announced, and the idea is that everyone will be referred to support services. Women will be referred to support services. Women who've offended will meet with the same judge each month, have intensive support and supervision from the probation service, and receive wraparound services tailored to their individual needs. The women who will be targeted in this West Midlands initiative will all have a history of reoffending and will be at risk of a short-term prison sentence. But are there any pitfalls here? What about net widening? Will there be a push of women to problem-solving courts so as to access mainstream services, adding more appointments into chaotic lives with the problem of breaches for not meeting conditions requirements? What training will magistrates be given? Do all women need problem-solving courts? Is this a way of reifying the differences by having problem-solving courts for women, but not for men? Does the minority status of women, simply fewer of them, justify problem-solving courts for women, but not for men? Is it better to focus on the specific problems, such as drugs, rather than having courts for men and women? Let me return to the idea of the gender equality duty and its implications. Gender Equality Act 2006, later subsumed within the Equality Act of 2010, which, as I've said, brought different legislation together, imposed specific equality duties on public authorities in relation to groups who shared the following characteristics: age, disability, gender reassignment, so on and so forth. It differed from earlier legislation in 2 respects: by requiring public authorities to be proactive in eliminating discrimination and harassment, rather than merely reacting to complaints, and by requiring public authorities to promote equality of opportunity, as well as to avoid discrimination. Positive action, not just defensive actions. Well, these measures have implications for the sentencing of women because they require the courts to avoid discrimination on grounds of sex and to advance equality of opportunity by responding to gender-specific disadvantages experienced by women and by meeting their gender-specific needs. But avoidance of discrimination has led to what Mida Chesney-Lind has sometimes described as vengeful equity. The treatment of women changing to match the treatment of men, increasing convergence in the severity of sentences imposed on men and women. Slight detour at this point, because I want to tell you about the sentencing advisory panel, which preceded the sentencing council. And Andrew Ashworth, when he chaired the sentencing advisory panel, provided a specific briefing on the sentencing of women and argued that the gender equality duty introduced by the legislation required the same principles of sentencing to apply to men and women. However, this was qualified by stating that the ways in which these principles should be put into effect would likely vary given the different profiles of male and female offenders. But he emphasised that there should be no sentencing on the basis of people's sex and that gender neutrality should apply. At the same time, there was recognition that a disproportionate number of women appearing before the courts have experienced physical, sexual, and mental abuse, and that such victimization can have significant significance for sentencing. So in addition to the so-called generic factors of mitigation that affect offender culpability, the sentencing advisory panel urged the courts to consider the differential impact of sentences on women, usually via personal mitigation. However, the issue is whether there is collective vulnerability of all female offenders that arises from their minority status within the criminal justice system. The panel recognised other things that would have relevance for women when it came to sentencing, emphasising that the threshold for custodial sentence must be met. And the panel also warned against up-tariffing for women because of a perceived lack of suitable community provision for women. The panel didn't venture to consider the more innovative aspects of the gender equality duty, which concern the promotion of equal opportunities. Incidentally, the Wedderburn Committee, led by Dorothy Wedderburn in 1998, had argued precisely that the criminal justice system should create equal opportunities. And Dorothy Wedderburn and colleagues argued that the geographical dispersal of women's prisons had meant that opportunities for skills training and education were more limited and barriers to resettlement more retractable. Therefore, they argued that women should receive community penalties instead. Over time, concerns about the collective vulnerability about women have rather been overshadowed in the development of new guidelines, both generic and offence specific. But the now Sentencing Council has recently turned attention to equality and diversity in its work, and it commissioned the University of Hertfordshire to examine trends in sentencing, amongst other things. And it's quite interesting to see what it actually promotes, or what it actually said. It did find some differences. They reviewed sentencing. They found some differences in the sentencing of men and women, men more likely to receive immediate custody than women for specific offences, for example. Their recommendations were these. Consider an extra step to the existing guidelines, adult guidelines, and consider the offender's personal circumstances, keep them in mind. I believe that this is something which Professor Sir Anthony Bottoms had mentioned in his own review of the Sentencing Council's work. They also recommended a qualitative study on the lived experience of offenders with mental health issues. Well, we've already learned that a high proportion of women have mental health conditions, so that might be useful. The last point is really interesting because they recommended undertaking further exploration of sentencers' attitudes about female offenders to understand the role their perception of equity has in sentencing. Specifically, they say further research could examine whether leniency is applied equally to all women or selectively, and whether factors such as perception of blameworthiness, gender roles, and of the paternalistic role of the court influence the sentencing of women. Indeed, the Sentencing Council is setting out to consider whether specific guidance is needed for female offenders. But do we really need pink and blue sentencing guidelines? Would this enhance justice, or would it detract from it? Is gender the critical factor in all cases? I mean, goodness me, when one looks at the sentencing guidelines and sentencing aims, there are already problems. Andrew Ashworth has described the aims of sentencing, for example, as a pick and mix approach. I think it's more like a club sandwich with dessert proportionality providing the bread within which the other aims, reduction of crime by deterrence, reform and rehabilitation of offenders, protection of the public, and the making of reparation by offenders, might be put into the middle of this club sandwich. So, do we really need pink and blue sentencing guidelines? What about women who've not experienced abuse of one sort or another, or mental health challenges? What about men who have experiences of abuse of one sort or another, or mental health challenges? What about intersectionality, compounded vulnerabilities, and gender fluidity and trans issues? What about victims who are offenders, offenders who are victims? We know that very often there is overlap. So as I say, the Sentencing Council has said that the exploration of the need for specific guidelines for women is going to be part of their 5-year strategy. I think that the issue is going to preoccupy me for the next 5 years too, because I'm going to be working with colleagues in the Sentencing Academy on precisely this issue. What are the other possibilities? One of my arguments is that it's perfectly possible to differentiate between men and women, or individuals in terms of their needs, in the form of the penalty, but I advise against differentiating in terms of the level of penalty. Over the past 2 decades in particular, we've seen the emergence of a policy stream for women in England and Wales, which aims to address the needs of women, together with those at risk of offending. We've seen more coordinated work across government departments. We've seen the emergence of a whole network of community centres for women, a resource in the community just for women. There's no such resource for men. But the idea is that it is a resource. It isn't that sentencing changes according to whether someone is a man or a woman. It's just that this is a particular resource for women. The Together Women programme, involving 5 community centres for women, emerged under the Labour government in the early 2000s. 5 such centres in 2 regions, offering holistic wraparound support and multi-agency involvement, addressing a wide range of problems relating to social exclusion, debt, domestic abuse, substance abuse, low self-confidence and self-esteem, debt advice and employment training included. There's also been a specific scheme to divert women from the criminal process as part of the National Conditional Caution Framework, though we don't yet know what the recent changes from 6 out-of-court disposals to just 2 cautions will have. Baroness Jean Corson's commissioned review of women with particular vulnerabilities in 2007 endorsed the idea of community centres for women, and indeed recommended the closure of women's prisons as we know them. Government didn't buy that one, rejected that idea, but recognised the need for differentiation in the form of penalty, but not in the level of penalty. In other words, no departure from the principle of desert, a key principle in practice. Sorry, this was just to say something about the community centres. Eventually, we've seen the development of 40, nearly 50 community centres for women, fairly unevenly spread across the country. But alas, some have had to close because of a lack of funding. But as I say, it's been the utilisation of the same sentencing criteria, no change there. The centres for women have proved to be a positive experience for women, with notable success in actually reducing reoffending, and the Tavistock Institute has produced an overview of the effectiveness. I hope my message is becoming clear that I'm not in favour of extensive differentiation between men and women when it comes to sentencing and criminal justice, at least not at the level of sentencing. I think departure from the principle of desert will simply create more discrimination. But we could look elsewhere. We could go on a journey to Scotland, for example, and think, well, what are they doing there that we could perhaps learn from? Well, Scotland is ahead of us. Under Scottish legislation, the court must not pass a custodial sentence of less than 12 months unless it's considered that no other method of dealing with the person is appropriate. In other words, they've created a presumption against short sentences. Initially, the presumption against short sentences was for 3 months. This was increased to 12 months in 2020. Well, this kind of approach would have the advantage of not discriminating between men and women, but at the same time, proportionately more women would benefit because it's women who tend to get the short sentences of custody. And so it would be a way of facilitating greater use of community penalties. I'm told that David Walk was considering the possibility for England and Wales in his brief period as Secretary of Justice, but nothing has come to fruition. Second positive initiative in Scotland concerns community custodial units. You'll remember Jean Corston wanted to close women's prisons. The government poo-pooed that idea, dismissed it very quickly. Well, in Scotland, as in England and Wales, and in Northern Ireland, there's been full concern about the rate of female imprisonment and the impact of imprisonment on criminalised women for 25, 30 years or more. And Scotland has created 2 community custody units for women, one in Dundee and one in Glasgow, so that the women are actually nearer to their homes, nearer to their children, they have children. Visiting is easier. There is easier access to community resources, which are being poured into those centres too. And the whole regime is taking account of the way in which women learn and cooperate with each other, and taking account of women's gender-specific needs, drawing on all the evidence that we have to date. So much to learn there. You'll be wondering why I called this lecture Sen and Sensibility. I'm a great fan of Amartya Sen and wanted to get him in somewhere, but that's not my only reason. His concerns take us well beyond criminal justice, of course. He asks whether justice is an ideal, forever beyond our grasp, or something that may actually guide our practical decisions and enhance our lives. Sen is all about enhancing justice and removing discrimination. He acknowledges that there's no perfect justice at all. He says justice cannot be indifferent to the lives of people, that people can actually live. Indeed, he writes about the importance of facilitating the development of capabilities. The Sen capability approach is a moral framework. It proposes that social arrangements should be evaluated primarily according to the extent of freedom people have to promote, as well as achieving functions. Misread that. The Sen capability approach is a moral framework. It proposes that social arrangements should be evaluated primarily according to the extent of freedom people have to promote, as well as achieving functions they value. In other words, enhance capabilities and you expand people's real freedoms. Can this be translated into criminal justice speak? I think so, if we accept that the state has a duty to care for people who've offended, as well as to punish, to facilitate the development of capabilities, the power to do something, the power for people to change, leading to increased integration and accountability. These things might stem from this. Of course, the duty of care itself, duty of care to offender as well as victim, is something to be debated. But certainly there are evident benefits for potential victims, potential benefits for communities too. We give care to the offender. Well, how best to do this? How best to facilitate this without creating new forms of discrimination? And this is where I return to the idea of differentiation in the form of penalty and interventions, not in the level of sentencing. Sen and sensibility, therefore, means a criminal justice system, a sentencing system, which can appreciate and respond to complex needs and influences without creating new forms of discrimination in separate sentencing systems, sentences, or indeed pink and blue sentencing guidelines. Equality is different, but not too different. Thank you very much.